the Attorney General for Northern Ireland on the devolution issue under paragraph 34 or Schedule 10 to Northern Ireland Acts of 199.
Mr. McGleenan, one or two housekeeping matters to start with. We've got an application before us from the official solicitor for permission to file a witness statement by the official solicitor, and we're minded to grant that. And we also have an application on behalf of the charities for permission to file an annex to their written case concerned with safeguards, and we're minded to grant that also. And the only other matter I think I need mention is that we have a lot of people to hear. It's obviously going to be important that people stick to their timings, and I will be severe if they don't. Ms. McGleenan.
Yes, that's understood, my Lord. My Lords and Ladies, I appear with the Attorney General for Northern Ireland, Dame Brenda King, and Mr. Rocky Keane, who will present the reference you will hear later today from the Lord Advocate, and over the next days a number of other parties as set out in this. The Attorney General has brought this reference before the Court pursuant to the devolution procedure in Schedule 10 of the Northern Ireland Act. She seeks to determine whether proposed modifications to Code of Practice, which the Minister of Health seeks to introduce, are compatible with Article 5 of the Convention. If modifications are not compatible, then the Minister will have no power to make provisions. The operative provisions in respect of the Northern Ireland Act are set out in the bundle at pages 303, 314. You don't need to go to those. Those are Section 24 of the Northern Ireland Act and Schedule 10, paragraphs 1 and paragraph 34. So this is a reference that is made outside of existing proceedings, so there are no extant proceedings. You can find the reference itself at page 269 of the main hearing bundle, and you can see the question that's posed therein. It relates specifically to Deprivation of Liberty Safeguards Code of Practice, which is made under Section 288 of the Mental Capacity Act Northern Ireland 2016, and it's directed to a series of amendments which speak to the question of giving of valid consent to a potential deprivation of liberty. Because it is a reference outside of any extant proceedings, the Court doesn't have the benefit of a first instance judgment or a Court of Appeal judgment to deal with. So I will, with the Court's permission, take some time to sketch the policy and statutory background to assist the Court with the 9,000 or so pages it has in the electronic bundle. I will focus on the Northern Ireland aspect of the case. You will hear in due course from subject specialists in respect of Scotland, England and Wales. But I will touch on that territory, acutely conscious of those who are to follow in respect of that. The broad outline of my submissions, I'll address 5 topics. Firstly, I'll consider the applicable statutory scheme in Northern Ireland, the Mental Capacity Act 2016. Then I'll turn to look at the relevant Strasbourg jurisprudence in respect of Article 5, with a particular focus on the question of valid consent. There's a great deal of authority on this issue, but that will be our focus. I'll then turn to the domestic law and the jurisprudence here, and in particular the judgment of this Court in Cheshire West from 2014, and I'll take some time with the analysis in respect of that judgment. I'll then turn, fourthly, to the policy responses that have developed in reaction to the Cheshire West judgment. I'll look at some Law Commission responses, the Joint Committee on Human Rights, and various proposals to address issues that have arisen. And then finally, I'll return to the draft Code of Practice to test through the question that's been raised and to volunteer an answer. There has been some skirmishing in the written cases about whether or not this is a reference that should proceed. In the absence of facts, I proceed on the assumption that we're here to deal with the reference, and I don't need to take up time with that. Moving to the subject matter of the reference, the focus of the case is on the phenomenon of social care detention, wherein many thousands of people with diminished mental capacity who are resident in forms of social care placement, which might be residential homes, care homes, assisted living placement, or even their own homes, are considered to be deprived of their liberty for the purposes of Article 5 of the Convention. Until the end of the last century, the idea that persons outside of institutions with mental capacity issues would be deprived of their liberty would have appeared counterintuitive. The legal model which we worked on until then was based on institutions where individuals were incarcerated because of mental health issues or a lack of capacity. And the concept of deprivation of liberty does not translate easily into the later model of caring in social care terms in the community. And a lot of the case law relates to the transitioning from institutional incarceration into care in the community, into social care, and that's where the concept of social care transformation detention arises. The policy driver towards social care of that nature was directed to increasing autonomy and maximising liberty by releasing people from institutional living. And the idea that transition to that environment would involve a deprivation of liberty to many would have seemed oxymoronic. Indeed, those points were made in some of the judgments in the Cheshire West decision in 2014, to which I will return. The issue that has given rise to the reference from Northern Ireland, and it's an issue which arises across the jurisdictions of the United Kingdom, is that where a conclusion is reached that someone in social care with a mental incapacity issue, where the conclusion is reached that they are deprived of liberty, that engages elaborate statutory procedural safeguards and processes involving deprivation of liberty authorisations. And in Northern Ireland, there are about 4,000 of those currently in place. For a helpful academic commentary for the Court's reference on this issue, we've included a valuable text in the Bundle of Authorities, a book by Dr. Series on these legal issues, and you'll find that for your reference at page 6036. I won't go to it now. The statistical information before the Court demonstrates the problem that I have sketched for you. And if I could ask the Court to take a moment to consider some recent Department of Health in England statistical material on this issue. You'll find this at page 7845. These are Department of Health statistics from 23-24. The font is small, I apologise. The document records the empirical numbers of DOLS applications, Deprivation of Liberty Safeguard applications received in 23-24. And you see by the middle of that page that there were 332,455 for that year, an increase of 11% on the previous year. You will see there's a significant proportion of them were urgent applications. Moving to the next paragraph, when one looks at the numbers which were fully assessed, you will see an estimated 145,945 were fully assessed during the same period. Evidently, there is a gap and growing backlog in relation to applications of that type. You will see that in terms of the assessed applications, almost all of them are granted. On the next page, 7846, about halfway down, fully assessed applications not granted was only about 3%. So we have a very significant process in respect of deprivation of liberty authorisation, involving about 1/3 people per annum, for whom these processes are engaged in light of the Article 5 analysis that currently applies. This document is also a helpful summary reference point for the general issue. If the court goes to page 7853, you'll see at the top of that page a description of the Dáil's safeguards and what the process is, how it applies when somebody who lacks mental capacity is being deprived of their liberty in a care home or hospital in order to keep them safe for harm. Those provisions were introduced in an amendment to the Mental Capacity Act 2005. That followed from the decision in the Strasbourg Court of HL in the United Kingdom, known as the Bournemouth case. So this scheme is a reaction to that Strasbourg judgment. So you'll see that the MCA, the English Act, was amended to bring in those safeguards in 2009, and you'll see the 4 bullet points in respect of the safeguards that apply as a consequence. I'll pass over the summary of the Supreme Court judgment in Cheshire West because I'll return to that in some more detail. And on the top of page 7854 is a summary of the policy responses to Cheshire West. That's my 4th topic, and I'll return to that in a little more granular detail. At the bottom half of page 7854, you see a description of the Dáil's process, and this is in England and Wales, but similar process applies in Northern Ireland. And you'll see that process, the application process, begins when a potential deprivation of liberty has occurred or is about to occur. And the responsible care home or hospital or site begins the application process at that stage. You'll see 2 paragraphs below that. A local authority is required to appoint at least 2 people to carry out 6 assessments. They include a mental health assessor, a best interest assessor, one will be a medical practitioner, and they must apply a series of criteria to the assessment, and those are set out in the bullet points below. Again, I'll not dilate on those in detail. They include, you'll see we're in 7855, assessments of the best interests of the individual patient, and when all of those criteria are met, and if they are, the individual can be legally deprived of their liberty by the hospital or care home. So this is the process at the centre of the reference. Similar.
This in England and Wales is for care home and hospital.
Yep.
But are you saying that this is the process in Northern Ireland, which I don't think has that same distinction between deprivations of liberty in care homes and hospitals and other deprivations?
Yeah, the reach is wider in the Northern Ireland
yes, but is this the process that applies in Northern Ireland more generally, even if it's
more generally
in a care home or hospital?
Yes, the broad concepts apply in Northern Ireland, but I'll show you there's a greater reach, and there are some other material differences. But that's just to sketch the issue for the court.
Is Dáil's applied more widely in England and Wales to cover cases like MIG and MEG, where someone isn't in a care home?
That's what we understand to be the case, Lord, yes.
Yes. So while this process refers to the care home and hospital, it in fact is applied more widely, not just in Northern Ireland, but also in England and Wales.
Yes. That's by way of sketch of the position generally. Can I take you to the Northern Ireland statutory scheme?
Which would like to be corrected by Virginia.
Yes. Griffin and Mr. Rutkean, outside of the care home arena, there's a court order procedure that's required. So
there's a court order
protection, yes.
Yeah, that's the court of protection.
Yes.
Yes.
Sorry, I'm moving to the Northern Ireland legislation, which you'll find in page 322. So, in Northern Ireland, we have a Mental Capacity Act 2016, which is similar to, but not identical to the English legislation. It is a piece of legislation that was intended to ultimately replace the mental health order legislation, the Mental Health Act, and to bring together in one single statute all the provisions that are required for dealing with mental health disorder and through to capacity issues. It has not been fully commenced, and only part of the Act is presently in force. But for our purposes, it does engage the relevant provisions in respect of deprivation of liberty. You'll see page 322, it's a statute that's based on principles relating to capacity. So the thrust of the provisions that follow in section 1 are directed to giving effect to the autonomous choices of individuals where they lack capacity, taking steps to support them in their decision making. And you'll see that's reflected in sections 3 and 4 and page 325. The statute directs attention to supporting individuals in order to make their decisions. So it's a statute that's directed towards maximising the autonomous choices of those who have capacity deficits. Our focus is in respect of Part 2 of the Act, and that begins at page 330. So this is the part of the Act which deals with lack of capacity, protections from liability, and safeguards. And this has been partially commenced in respect of matters of deprivation of liberty. There's a commencement order. You don't need to go to it, but it's in the supplementary bundle, page 117, for consideration, which brings this part of the Act into effect. So the purpose of the provision is to protect individuals from liability for acts taken in the best interests of persons lacking capacity. And you see the conditions that are applied in 9.1a. It's an age condition. 9.1b refers to care, treatment, and personal welfare. C requires reasonable steps to be taken to establish capacity. And then at 9.2, as you'll see, it says D doesn't incur liability in relation to any act, and certain qualifications in respect of that. These are safeguards. You'll see over the page, subsection 4, page 331. Additional safeguards apply in 4D in particular, in respect of treatment and where there is a deprivation of liberty. So that brings into play section 24 of the Act, which you'll see at page 341. So heading is deprivation of liberty. It applies where the Act amounts to, or is one of a number of acts, which amounts to a deprivation of liberty. The protection from liability only applies where the detention is authorised, at 24.2b. There's a requirement for a prevention of serious harm condition to be engaged. You'll see on the facing page 342, section 25 sets out the process for authorisation. So 25 subsection 3. Detention is authorised if at the time the act's done there's enforced an authorisation granted by a panel under Schedule 1, or for an urgent process, an authorisation for short-term detention for examination, etc. So these are usually done by trust panels. Section 25, subsection 5 identifies the prevention of serious harm condition.
But by the time you get to this section 24 and 25, are you already dealing with somebody who has been determined to lack mental capacity to take this decision?
Yes.
So the mental capacity decision is taken first, and then all these provisions then kick in if
Yes.
they're being deprived of them.
Exactly. So the authorisation process then has again, a detailed infrastructure, which is set out in the schedules. You'll see that at sorry, before I go to the schedules, actually, page 350 and onwards sets out the process for extensions of authorisation. So if an authorisation is granted, which removes the potential for liability, there's then process for extensions. They are usually granted for 6 months in the first instance. Section 39, page 351, extension reports are required for an extension, again with input from medical practitioners. If they're produced, there can be an extension for a further 6 months, and there are rights which apply then in respect of tribunal access, and you can see that at section 45, page 355. There's a requirement to notify the Attorney General of the engagement of these processes. You see that in section 50, page 359. And there's a right for the Attorney General to refer these matters to a tribunal. That's in section 47, page 357. The Act also makes provision for offences, and if you go to page 398, you'll see part 13 of the Act.
So what's the page number again?
398, my Lord.
Thank you.
And you will see specific offences in respect of the unlawful detention of persons lacking capacity. That's on page 400, section 269. So a person commits an offence if they knowingly detain in circumstances amounting to a deprivation of liberty a person who's 16 and over and lacks capacity in relation to detention, and whether he or she should be detained. So we have criminal liability, and this is a different feature of this Act as opposed to those which you'll hear about in England and Wales and Scotland. So detaining someone in those circumstances amounting to deprivation of liberty without an authorisation gives rise to potential criminal liability. A prosecution can be brought by or with the consent of the DPP. You see that at the bottom of that page, 269, subsection 6. But this is an important feature of the statutory scheme because it introduces questions of legal certainty and the quality of the law, which bear, we say, close consideration. The provision for the Code of Practice is found in section 288, which is at page 406. So the department, the minister here, must prepare and issue one or more codes of practice, and a code of practice is required for the deprivation of liberty.
Could I have the page number again, please?
Sorry, my lord, that's 406.
Thank you.
The 407, subsection 4, the department may from time to time revise that code of practice, and that's the issue that brings us to this court, because the minister has these proceedings, these processes have been in place for a number of years, purported to revise the code, and the draft revised code is attached to the end of the reference, which we'll come back to in due course. The code is important, you'll see, for the reasons that become clear in page 408, section 289. So it's a matter that is to be had regard to by anyone acting in a professional capacity and so forth. Subsection 3, 289, subsection 3, where an issue arises in court or tribunal conducting any criminal or civil proceedings, then the provision of the code or a failure to comply with the code is relevant to a question arising in the proceedings, and it must be taken into account in deciding that question. So that links back to our point about the criminal offences that are in place for individuals. There is then page 410, the section dealing with definitions. This is section 306. And if you go to page 411, about a third of the way down the page, you will see the definition of deprivation of liberty. So this is important because it raises a challenging source of law question. This provision is the means by which the relevant law is defined in this area. And so you see it says it means a deprivation of liberty within the meaning of Article 5.1 of the Human Rights Convention. And for the purpose of any reference to deprivation, it does not matter whether it was a deprivation is done by a public authority or not. So the definition of Human Rights Convention, you'll see at the top of page 412, is have the same meaning as the Convention in the Human Rights Act, 1998. It's not actually in the papers before the court, but if you go to section 21, I'm not asking you to do this now, but if you go to section 21 of the Human Rights Act, you will see how the Human Rights Convention is defined. And that's quite important as well, because it is defined as the 1950 Convention as it has effect for the time being in relation to the United Kingdom. So we do have to take care with examining exactly how this Section 306 provision works. It is an unusual provision. There is a very close analogue in the 2005 Mental Capacity Act in it, not exactly the same in textual terms, but very, very similar. We have not found many other examples that adopt this formula. There is an example in the Modern Slavery Act. Again, I don't think it's in the papers before you. Section 1. There is a similar provision in a Welsh Education Act, but we've been unable to locate many more examples. It is important that we examine the nature of this source of law, because, and this was a topic that did feature in the Cheshire West appeal in 2014, it is not the same as the Section 2.1 obligation in the Human Rights Act. The Section 2.1 obligation in the Human Rights Act is firstly directed to the Convention as patriated into domestic law by that Act. So it's the Convention in the schedule to the Act. It is also an interpretive obligation. So it's engaged whenever a court is determining an issue arising in proceedings. And it requires that court or tribunal to take into account, so far as is relevant to the proceedings, any judgment, decision, declaration or advisory opinion of the European Court of Human Rights. But the Section 306 provision and the analogous provision in Section 64, subsection 5 of the Mental Capacity Act in England is not interpretive in nature. It identifies a body of law which takes effect in our jurisdiction. So it defines the content of the general law, not just for courts, importantly, because what I've shown you is the general scheme in respect of authorisations. The authorisation schemes are operated by healthcare professionals at a coal-face level, and when they're assessing questions of deprivation of liberty, that act which they engage in must be mapped against the Article 5 body of law. So it is importantly different in that regard. There is some consideration of this in Cheshire West, and I'll come back to that when we look at that judgment. But it does give rise to a question about the nature of this source of law and the consequence of it. Does it engage the mirror principle in classic ULA terms? Are we reflecting through a court interpretive process the effect of the Strasbourg jurisprudence? Or is this something closer to a dynamic alignment with the Strasbourg jurisprudence? In our submission, it is more akin to a dynamic alignment process than simple mirroring. That in turn, when one examines it, gives rise to its own challenges, because the European Court of Human Rights is not a law-making body. It doesn't create a body of statute law. It reacts to applications that come before it and provides rulings and judgments. That gives rise to the corpus of law. It is notoriously a court that operates according to the living instrument concept, Tyrer versus United Kingdom. So the norm which we're looking to in coming into our domestic legal system is one which itself is not fixed. The boundaries can move as the jurisprudence develops in whatever direction. The consequence here is that domestic legal obligations relating to deprivation of liberty are tied to potentially fluctuating norm. You have dynamic European Court jurisprudence. When we bring it back into this context, the challenges that arise, Section 306 in the Northern Ireland scheme requires the application of that law in a binary manner. So you either have a deprivation of liberty or you do not. And the consequences of that judgment are important in terms of civil liability, criminal liability, the engagement of a resource-intensive state infrastructure. So a great deal turns on it. And here we reflect also on the convention value of legal certainty. And there's a need to ensure that the legal certainty values are upheld, particularly given the consequences that follow. So this, we say, points towards the need for scrupulous attention to the boundaries of the Strasbourg jurisprudence, because it is travelling through Section 306 and Section 64, subsection 5 of the English Act, directly into our legal system. So our analysis has to be closely aligned to what the Strasbourg jurisprudence actually is. That is the task which Parliament has set for us. I can show you the English provision.
Does a deprivation of liberty mean a deprivation of liberty within the meaning of Article 5.1 of the Human Rights Convention, as interpreted by the Strasbourg Court?
Yes.
Right. What happens if the Strasbourg Court is interpreted in a different way than this court?
Well, what ought to happen is the domestic, whatever public authority or courts involved in applying the analysis should follow what the Strasbourg Court has done.
What happens if this court is interpreted in one particular way and a lower court is then presented with an argument that this court was wrong and it should apply the Strasbourg jurisprudence?
Yes.
What happens then?
Well, that's a very interesting question, because it's a point that's come up in a number of convention-related cases as to the extent to which the classic rules of precedent apply when one's looking at the Section 2 interpretive obligation under the Human Rights Act. So that's come up in Dalton, for example, and I think in JR 123, other cases where that point's arisen. And suggestion is that the constraints of precedent are different in that context. Now, what I would say, my Lord, is that here we're not dealing with Section 2.1. We're dealing with Section 306, which brings the ECHR jurisprudence directly into our jurisdiction. So, and this isn't straightforward and may have its own consequences. The domestic court should apply the Strasbourg jurisprudence.
I have to say I'm struggling a little bit to see the force of the distinction that you're making, because if one's within Section 2.1 of the Human Rights Act and the mirror principle, the domestic courts have to understand the Strasbourg jurisprudence properly and mirror it if that's what is required by domestic law. Yeah. And so that may be dynamic, because that might change over time because of the living instrument doctrine.
It may not make much difference when a court's applying it.
And then going to this Section 306 direct passporting idea, going back to my Lord's question, I'd have thought that if you have an up-to-date decision of this court interpreting authoritatively how it understands the Strasbourg jurisprudence, I can't see why that wouldn't bind lower courts in this jurisdiction.
The question that follows from that is whether or not there's actually a dissonance between the interpretation of this court and the Strasbourg jurisprudence as it currently stands, or even as it stood at the time.
Well, if it's moved on, that's
yes.
why, but that's why I said an up-to-date decision of this court that's looked at the Strasbourg jurisprudence to date.
Yes.
Sorry, and so if that's the position, would the lower courts be bound by a decision of this court interpreting that?
If that's the position, yes.
So the question then is, has the Strasbourg jurisprudence moved beyond
or
that?
Was it correctly interpreted at the time when the original binding decision of this court was made? Or is
well,
it?
that's what I don't understand.
How can that be? I mean, if you've got an up-to-date decision of this court on a Strasbourg jurisprudence, how can the lower court second-guess it?
Well, the lower court ought not to. That's the case, I think. That's where that follows, and that's what has happened to date. There have occasionally been misgivings expressed, but the ultimate position is the position should be followed in respect of, for example, Cheshire West. There are some subtleties to the argument in the context of this case. There's dispute about whether or not the issue which we're raising, the valid consent issue, was actually addressed by the court in Cheshire West. Whether, in fact, the analysis in Cheshire West correctly examines the Strasbourg jurisprudence on that point.
Right, but my understanding, that would be a sort of classic way of saying a precedent isn't binding because it's per incuriam or something like that.
Yes.
But you seem to be making a point that there's some radical distinction between our ordinary rules of precedent and what happens here, and that's what I'm struggling to understand.
But I think the point I'm making is not so much in terms of the precedent that binds a court, it's about the effect of the legal position on the general application of the deprivation of liberty law. So it's not just courts who apply that law.
Right.
But
the courts declared the law, so I understand you have officials or indeed possibly family members who are applying the law, but they likewise, if one's dealing with an up-to-date decision of this court saying what the proper interpretation of the Strasbourg jurisprudence is, I just thought they'd be bound by that just as a lower court would be.
I think that's probably right. We're disposed to accept that.
Right, okay.
I think what's clear from both Section 64.5 and our Section 306 is there's a need for a particularly close attention to what the Strasbourg jurisprudence actually is.
I mean, I understand close attention. I'm not sure I understand particularly close attention because under the mirror principle, you need to understand what the Strasbourg jurisprudence is and therefore pay close attention to it.
Yes. Well, perhaps I'll not add that.
All right.
I was simply going to give you a reference to Section 65.4, which is to the same effect. It's page 736. Slightly different textual provision, but to similar effect.
I'm sorry, what are we picking up on page?
That's the Mental Capacity Act.
Oh, I see. That's the England
Sorry.
and Wales position. Is that right?
Yes, that's right. 736.
Right. Thank you.
Now, there has been discussion, certainly parliamentary discussion, as to whether or not this Section 64.5 or Section 306 approach should be replaced by a statutory definition of deprivation of liberty rather than tying it to the Article 5 jurisprudence. And that debate has ebbed and flowed. I just wanted, before I go into the Strasbourg case law, just to pick up the House of Lords Select Committee, which examined this issue in 2014. You have their report on the Mental Capacity Act 2005, beginning at page 6756. So this is post-legislative scrutiny of the Act after the amendments came in and after Section 64.5 was first given effect. And you'll see discussion of this issue at page 6853, because there was a call for a replacement of the Section 64.5 mechanism with a particular statutory definition of deprivation of liberty. You'll see that at paragraph 279 on page 6853. This report came out just before the decision of the Supreme Court in Cheshire West, I think 1 or 2 weeks before the judgment issued, and you'll see reference to that in paragraph 280 and 282, government indicating they would review the position of a definition after the decision of the Supreme Court. And views being expressed that it wasn't possible to freeze the definition of deprivation of liberty, as it would be subject to the evolving case law of that court. So the position reached by the Law Commission at that time was in agreement with the government and the official solicitor that no statutory definition is required. While the lack of a definition may reduce certainty, the term is intended to echo the wording of Article 5 of the Convention. The current statutory provisions are adequate to achieve this. So we're at that point considering and not progressing with the statutory definition, which points us to the Article 5 jurisprudence. What are we echoing in this context? And if I may now take the court to some of the case law that's relevant on this topic.
So there's the structure you're envisaging, if the guidance proposed is lawful, is that people would still have their assessment that they are they lack mental capacity to decide as to their residence.
Yeah.
But somebody would then decide whether they have validly consented to their confinement.
Yes.
And if somebody decides they have validly consented to their confinement, then none of that Section 9 or Section 24 or the Dole safeguards that we saw summarised, none of that would apply.
That's right.
They would just be where they are, consenting to where they are. Right. And who takes that decision as to whether they have validly consented?
Well, it's not clear from the ministerial code exactly who will do that. We know that there are processes in place that allow for best interest assessments under the current regime, which require an assessment of the wishes and feelings of the individuals. So there are questions which follow as to the appropriate safeguards, who does it, what oversight there is in respect of that.
So it might be part and parcel of the best interests decision as to where they should live.
It would classically be part of the care planning process. So you have someone who's got a major capacity issue. There will be questions for the social care authorities as to how they're cared for. That happens anyway and has to happen. And in the course of that process, there will be a means of ascertaining, if it's possible, what their expressions of wish and feeling are. And if it is positive towards their place of residence, then that may be sufficient.
So at the moment, they still have to decide, because of the best interest test, whether the person is happy to, looks as if they're going to be happy where they are.
Yes.
But the additional effect or consequence of that assessment would be that they're not being deprived of their liberty, so all those statutory provisions we were looking at would not be triggered.
Yes, and the risks of liability that attach to that, the potential criminal liability, civil liability, is all taken off the table. So we've set out a bit of detail on this in our written case at page 68, just for your reference. So, turning to the Strasbourg Authority, on this point, the starting point usually is the Guzzardi in Italy case, which you'll find at page 4157. This case...
Sorry, can you give that number again?
4157. Guzzardi in Italy is a case relating to the detention in essentially open prison conditions on an island off Sardinia of an individual awaiting trial for serious criminal charges relating to mafia-type offences. The question was whether or not the circumstance of that detention amounted to a deprivation of liberty. The relevant statement of principle that endures through all the later case law is found at page 4186.
Sorry,
4186.
86.
Paragraph 91 sets out the broad circumstances of the conditions in which the individual was confined. Paragraph 92 then refers to the right to liberty and notes that it's contemplating the physical liberty of the person. It's a point that's worth recalling. The interest is in physical liberty. It aims to ensure no one should be dispossessed of his liberty in an arbitrary fashion. It's not concerned with mere restrictions on liberty of movement. Those are governed by Article 2, Protocol Number 4, which of course were not ratified by Italy and not by the United Kingdom. And then the statement of principle. In order to determine whether someone's been deprived of his liberty, in the meaning of Article 5, the starting point must be his concrete situation, and account must be taken of a whole range of criteria, such as the type, duration, effects and manner of implementation of the measure in question. Then the difference between deprivation of and restriction upon liberty is nonetheless merely one of degree or intensity, not one of nature or substance. Highlight for you as well paragraph 95, the court responding to the government's objections, noting they're not without weight. It demonstrates very clearly the extent of the difference between the applicant's treatment in Asinara, the island, and classic detention in prison or strict arrest imposed on a serviceman. Deprivation of liberty may however take numerous other forms, their varieties being increased by developments in legal standards and attitudes. Conventions be interpreted in the light of the notions currently prevailing in democratic states. And the footnote you'll see at 31 is to the terror the United Kingdom case and the living instrument doctrine, which links back to the point that I was making earlier about the consequence of the Section 306 provision. And on the facts of the case, the Strasbourg court found that the circumstances there amounted to a deprivation of liberty. I then wanted to take the court to a decision which features prominently in the Cheshire West case and in later litigation. That's the decision in HM and Switzerland, which you'll find at page 4311. This is a chamber decision in a social care context. It's a case involving an older woman who had been in a state of neglect, and the local authorities became engaged in management of her care. There is an issue as to whether or not she was mentally capable to make decisions for herself, whether she had capacity, and you'll see some detail on that in paragraphs 21 through to 23. That's page 4314 to 4315. And the Appeal Commission who looked at her case, the Cantonal Appeal Commission, you see this at the bottom of paragraph 23, considered that she had a mental weakness in the form of senile dementia, and they would have considered her placement in the foster home was justified even if it wasn't for the relevant neglect. So it's a case where the facts are set out at page 4317 in respect of the applicant herself. It's a short judgment, and the court's assessment begins at 4319. So, paragraph 40 notes the distinction between Article 5 and Article 2 of the first protocol. Paragraph 42 applies the Guisardi test, looking at the concrete situation. Then paragraph 43 draws parallels with a case from Denmark, Nielsen in Denmark. And it's a case where a child was receiving treatment on a ward, but with restrictions. Nevertheless, the ward in question was said to be as similar as possible to a real home. That's the top of page 4320. Paragraph 46 of the judgment refers back to the Appeals Commission, which considered her case, and notes that the applicant hardly felt the effects of her stay in the foster home, which was mostly felt by her son, who did not wish to lose her mother. The applicant herself was undecided as to which solution she in fact preferred. For example, at the hearing before the Appeals Commission, she stated she had no reason to be unhappy with the foster home. 47 notes that she had agreed to stay there. 48, reference to the applicant being placed in that home in her own interests, but the court, taking those matters into consideration, taking into consideration the comparable circumstances of the Nielsen and Denmark case, included in the circumstances of the present case, her placement in the foster home did not amount to deprivation of liberty within the meaning of Article 5.1, but was a responsible measure taken by the competent authorities. So this is a case in the social care context where the expression of satisfaction by the individual in question was considered to be important for the purpose of assessing the deprivation of liberty. And this decision features in later debates on this particular issue. Next in time, we have the Bournewood decision, which is at page 4595.
So the page number again, please.
4595.
Thank you.
And this is again a case of an individual who was transitioning from institutional care, where he had been for almost all of his life, into the community, into social care, where he was looked after by foster parents, and where difficulties arose at the margins and the questions arose about his ability to give consent to the treatment that was being provided for him. It's the Bournewood case, this decision, which gives rise to the amendments in the 2005 Mental Capacity Act in England and Wales, with which we are here concerned. The relevant section of the analysis of the judgment begins at page 4622. You'll see at page 4624, the court's recording the arguments and recording paragraph 84 that the United Kingdom government relied on Nielsen in Denmark and the HM Switzerland case, which are the two that I've just drawn to your attention. The court's assessment begins at page 4625 from paragraph 89 onwards. So 89 is a classic Guisardi recitation. Paragraph 90 deals with whether or not the applicant was agreeing or consenting. Paragraph 91 is the central finding of the court. It identifies the key factor in the present case to be the healthcare professionals treating and managing the applicant exercise complete and effective control over his care and movements from the moment he presented acute behavioural problems in July 22, 1997. So the court here distinguished the HM decision. You'll see that at paragraph 93 on page 4627. So, reacting to the government's reliance on HM Switzerland, said, about 5 lines down, each case has to be decided on its own particular range of factors. While there may be similarities between the present and the HM case, there are also distinguishing features, noting that she was legal. It was not established she was legally incapable of expressing a view in her position. She had often stated she was willing to enter the home within weeks of being there, had agreed to stay. So that's a distinguishing feature found by the court in respect of the HM decision, which wasn't followed.
Just on the facts of this case,
Yes,
this is dealing with somebody who was, I think, agitated where he was and was being sedated.
yes. Yes. So it's not an obvious case for expression of a positive response to that. The interesting question would be, what would be the position of this individual whenever they returned to the foster care home where they wanted to be with the foster parents, Mr. and Mrs. E? Would they in that context be deprived of liberty on the current model? The answer is probably yes to that. The next significant development in the Strasbourg jurisprudence is in the case of Stork and Germany, which you'll find at page 4644. And this is an application brought in respect of someone who had spent over 20 years in various psychiatric hospitals. 20 months. Yes. 20 months. She had many hospital stays throughout her life, and this was a challenge to the most recent of those. The case is important because the court developed its jurisprudence beyond the Gazzardi analysis. And you'll see this from pages 4659 onwards. So there's a heading there dealing with the alleged violation of Article 5.1. Paragraph 71 sets out and references the Gazzardi test. The footnote links to Nielsen in Denmark and also to HM in Switzerland. The court then notes the regional court in Germany had found the applicant being deprived of her liberty because she neither expressly or implicitly consented to her stay there.
Which paragraph, sorry?
72, my lord, top of 4660.
Thank you.
Her circumstances are set out at paragraph 73, so in a locked ward under continuous supervision and control, not free to leave.
She had, the facts of these cases are quite important. This applicant, we're told, had attempted to flee,
Yes.
and had been fettered
Yes.
in order to stop her.
Yes. It's a feature of many of these cases, my lord, that we're looking to the expression of views and wills by individuals who are clearly not consenting by their actions to their confinement. The question is, what is the corollary of that? If views, wishes and feelings are relevant to whether or not someone is agreeing to be detained or disagreeing to be detained, they must also be relevant to a situation where they are content to be detained. That's where the analysis ultimately goes. So the case law, it's unsurprising in a way. Cases come before the court because individuals are complaining about their detention and complaining that it's a deprivation of liberty. And they're demonstrating by their actions, words and deeds that that's the case. The question is, what follows from that?
But if she attempts to leave and is fettered, then it's difficult to know whether her not attempting to leave again is because she remembers what happened last time, or whether she's now become accustomed and accepting of where she is.
Or whether there's coercion as a result, whether that's the tacit consequence. I accept that. I mean, the fact of all these cases, most of these cases will involve situations where individuals are objecting to their placement, but you'll see that some of them are not, and that's the important point which I'll come to in due course.
You can also take from the facts of this case and HL also that the individual in question was capable of forming an intention to leave,
Yes.
and indeed of carrying out that intention. So Now, that isn't always going to be the case with people in residential settings.
Yes. There will be some very minimal possible responses from some of the people involved. That's correct, my Lord. Our focus is on those who have the ability to express some view, wish, intention in respect of that, and what effect should be given to that, if any. What you see through the trend of these cases is that is considered to be relevant, legally relevant.
But it seems to be considered to be relevant to the question of confinement rather than consent, because that is then dealt with at 74.
Well, that's exactly the point, really. What the development of the jurisprudence in 74 is to add the subjective element to the consideration.
But the question of whether the individual is objecting or not objecting is dealt with in the context of the confinement element.
Yes.
Whereas your case is that it should be dealt with in the context of the subjective element, I think.
If we can just take it in its structure, so we see how this fits together. 73 is the classic formulation of the objective test, so she must therefore be considered being deprived of her liberty. 74 is the additional development, so the notion of deprivation of liberty, in the meaning of Article 5.1, does not only comprise the objective element of a person's confinement to a certain limited place for a not negligible length of time. Individuals can only be considered as being deprived of their liberty if, as an additional subjective element, they've not validly consented to the confinement in question.
I'm wondering if one can neatly pigeonhole these as two separate questions, entirely separate questions.
Often the approach courts, lawyers take is to try to compartmentalize these things into objective, subjective elements. There may well be marginal issues, but this is the tool that we've been given by the Strasbourg court, rightly or wrongly. And paragraph 74 of Stork is important because we have to ask as we go through the later cases what effect is given to that. If it is the case that individuals can only be considered as being deprived of liberty if they've not validly consented, then that's an important aspect of the analysis in any of these cases. You'll see, actually, there's a footnote in paragraph 74. Footnote 9 takes us back to HM Switzerland, and paragraph 46, which I'd highlighted to you on the way through, which is where the applicant in that case have been able to express her views about her detention. Paragraph 76 is also helpful. In regard to the continuation of her stay in the clinic, the court considers the key factor in the present case to be that which is uncontested. She had on several occasions tried to flee from the clinic. She had to be fettered to prevent her from absconding. Under those circumstances, the court is unable to discern any factual base for the assumption that the applicant, presuming her capacity consent, had agreed to her continued stay in the clinic. In the alternative, assuming the applicant had no longer been capable of consenting following her treatment with strong medication, she could in any event not be considered having validly agreed to her treatment. Then there's...
So, in the alternative, so strong medication on its own would have prevented her from validly consenting, is that right? How does that read across then into people who are suffering from Alzheimer's, who don't require medication but can't understand the question, can't understand whether to consent?
Well, there's a question as to whether there's other means or other information, or whether there's some support that can be given, or something that can be detected from their disposition that would allow inference to be drawn about wishes and feelings. That's what the code is directing to. No one's suggesting this is easy, but the Strasbourg jurisprudence seems to indicate that there is a place for consideration of expressions of wishes and feelings in respect of valid consent, and valid consent is a key consideration in terms of deprivation of liberty.
That's presented on the basis of a presumption of a capacity to consent.
In these cases, there won't be capacity to consent, legal capacity to consent. That will be absent. That's the issue. So there isn't capacity to consent. That's why we're dealing with all of these cases under the MCA. So it's
But in 76, you see the word presuming.
Yes. Sorry, my Lord, yes.
So what is your case then on someone who has very advanced dementia and is unable to express or indicate any view as to, or any wish to leave or to stay? Or are you saying this reference is not dealing with those sorts of cases, this reference is only dealing with people who lack mental capacity but still have the ability to form the wish to leave or form the wish to stay, and also to express that in some way?
It's the Minister and Department of Health's position that this will not resolve all cases. There will be a cohort of cases like the extreme dementia case, very advanced dementia, where there can be no meaningful expression, in which case they remain in the system.
So you accept at the moment at least that there is still a deprivation of liberty for somebody who is unable to move and unable to form a wish to leave.
Valid consent.
What we're dealing with is somebody who has no mental capacity but to decide about their living arrangements, but still can evince willingness or unwillingness to be there.
Yes, and that may be a significant number of cases. If we're looking at 350,000 a year, it may be a significant proportion of them. Not all, of course. Never going to be addressing all of that. So the proposal in the Code of Practice is to narrow the cohort who are drawn into the system through the deprivation of liberty analysis. Not all.
I find it very difficult to understand in what sense a person who's unable to form a wish to leave somewhere and may also be physically unable to do so can be said to be deprived of liberty at all.
As I was going to raise that point, is there Strasbourg jurisprudence saying that such a person is deprived of liberty?
I think there is.
And if you have somebody in a persistent vegetative state in the home, is that person being deprived of their liberty? I mean, surely not. If they're not, what about somebody who is so demented they're effectively catatonic, just spend a day in front of a television set? Is that person, in what sense does that person have any liberty which she can be deprived of?
That's why it's important. I probably flashed across it too quickly, but when you go back to Guzzardi emphasises that what's in play is physical liberty. That's what Article 5 protects, physical liberty. So the individual is in the PVS state, immobile, unable to communicate. It's difficult to see how there is a restraint or deprivation of physical liberty in that context that engages the whole machinery that starts the process off. My Lords.
And what about the old dear who is simply got out of bed in the morning, given washed and put in front of the television until it's bedtime? I mean, what liberty does that person have to be deprived of?
Well, again, on that analysis, you significantly narrow the cohort of individuals who will ever be caught by the deprivation of liberty safeguards.
Well, that may be.
But how are they treated at the moment? Are those people posited by my Lord Reid treated as if
Those are deprivation of liberty.
they are treated as deprivation of liberty cases? And your proposed revised guidance wouldn't affect that?
Not in cases where there's an inability to express any wish. Wouldn't necessarily affect that.
Well, again, I come back to the question, is there Strasbourg jurisprudence which supports bringing these people within Article 5?
Not expressly, my Lord.
Well, on what basis is the domestic law, given that it's tracking jurisprudence on Article 5, applying a deprivation of liberty regime to them?
Well, I don't have a direct answer to that. I think, and I'm not passing the point, but we'll reflect and come back on it. I think this issue goes in part to the the acid test and the Secretary of State's case. Our position is, and the attorneys looking at what the Minister of Health's done in Northern Ireland, is there is a difficulty. It requires a correction to mitigate the problem. The corrections proposed is the valid consent correction. There is another way of doing it, which is to look again at the overall test, the acid test, to see if, in fact, we shouldn't be capturing these at all. But our reference is about the valid consent point.
The anterior question to before consent is whether the person has been deprived of their liberty. Yes. And so, which I suppose does raise the acid test
yes.
issue.
Yeah. One way of putting it is to ask whether a person who lacks autonomy is capable of possessing liberty within the meaning of the Convention.
Yes. It's possible our Minister could have started in a different position and started further back in the analysis, and maybe that's work for another day. But the approach that's been taken here, and I'll show you how it actually lines up with various policy proposals elsewhere, was to start with the valid consent point, except what my Lord says. The whole purpose of engaging these processes is to respect the autonomy of the individuals, but if there is no autonomy, then it's not clear why that's necessary. In terms of the legal tools at our disposal, we highlight the Stork case because it brings the valid consent point very much into play. It is identified
but it rules it out on the basis if the person can't validly agree. The person can't consent. She's drugged up. There's so many drugs have been administered. She can't validly agree. She suffers from Alzheimer's or some other condition. They can't validly agree.
Yeah, I mean, this seems to be the difficulty that has arisen in the Cheshire West, in the reasoning of Cheshire West, that if you, once you accept that there is a deprivation of liberty provided, hypothetically, if a person were to attempt to walk out, they would be stopped. Then you say the objective condition is met, and then you ask, is the person capable of consenting to that? And the question almost answers itself, because they're not CAPACs. If they don't understand their situation, then how can they consent to it?
Yes. Well, what Stork leaves open, clearly, is the scenario whereby someone's not capable in that sense, but yet still a value is given to the expression of whatever it is they can communicate. And if there's a value given to that, and it's significant enough, then that neutralises the first part of the equation. That's the narrow space in which we're operating. The difficulty, when we come to look at Cheshire West, you'll see that the court very readily sets that value at naught, zero, no aspect of subjective consideration. Therefore, you remove that dimension completely.
Well, you don't remove it completely. What they said in Cheshire West is that that's what you take into account when you're considering whether it's in their best interest to stay there. So the legislation makes clear that the wishes and feelings of the person, despite their lack of mental capacity, are highly relevant to the question of whether, assuming that they're being deprived of their liberty, the court should authorise that or not. And I would have expected that if the person has to be chained to the sofa in order not to escape, then the court would be alerted to that, and that may think, well, should we be looking at some other way of dealing with this person? So it's not that their wishes and feelings are left out of account, they're just brought into account at a different stage.
Well, I accept that there is a place for that in the Dawes analysis. I showed you the 6 criteria, and one of them is the best interest analysis at that stage. We've already engaged the deprivation of liberty machinery at that point. That's in operation. The question is whether we need to get into that at all if you can ascertain from that same individual an expression of wishes and feelings which neutralises the deprivation of liberty at the first instance. And that's why I will come to Cheshire West and we'll look closely at it and see what the majority were saying about where the subjective test fits in. For present purposes, bearing in mind what we have to do with Section 306 of the Northern Ireland Act and 64.5 of the English Act. Stork is to be applied. It is relevant to the consideration. It's one of the analytical tools which you must use in cases of this type.
I'm just on Stork, paragraph 75, page 4660. The court seems to be focusing on quite a strict notion of legal capacity to consent. Because she's not, the woman hadn't been placed under guardianship, she's over 18, and then the court says, therefore, she had been considered to have the capacity to consent or object to her admission and treatment in hospital. That seems to be full legal capacity, doesn't it?
Yes.
So when the court then comes to, or in the context of the court adding the subjective element, which you get at paragraph 74, in the context of this case, they seem to be focusing on full legal capacity to consent, and they say, well, she didn't consent. Yes. Is that right?
I think that's right. Full legal capacity, and she is objecting.
Is a key fact, let's say 76, a key factor in the present case is that she several times tried to flee.
They say at 77 her lack of consent is the decisive feature, distinguishing that case from HM Switzerland, which we've already looked at.
Yeah, so, I mean, as my law points out, 76, I mean, she's tried to flee, and then they go on at 76. Under these circumstances, the court is unable to discern any factual basis for the assumption that the applicant, presuming her capacity to consent, had agreed. I mean, she's tried to vote with her feet and has been prevented from doing so.
In contradistinction then to HM Switzerland, where again the view is that the applicant in HM Switzerland was, it says, legally capable of expressing a view and had been undecided whether she wanted to stay, and they reached the conclusion she didn't object. These are cases where there's legal capacity. The more difficult category of cases are those where there's an issue about legal capacity or that there isn't capacity. What one does at that stage with these expressions of views.
But HM Switzerland doesn't break it down into the objective and subjective.
Predates it. So Stork is a post-dating development of the law, so that brings us forward in the analysis.
Yes, the attempt to leave cannot be determinative because, as they say in paragraph 77, in HL against the United Kingdom, there was a deprivation of liberty where there was no attempt to leave.
Exactly. Key factor in HL was being under the supervision and control constantly of the staff.
He made it very clear that he was unhappy where he was.
Yes.
To the extent that he was being sedated to make him compliant.
Yes, we have an expression of view in that regard.
Yes.
I wanted then to turn to...
Because HL was very important to the majority decision in Cheshire West.
Yeah, it is. I wanted then to turn to a sequence of Strasbourg decisions which focus even more sharply on the subjective component, the second limb of the Stork test. And these are mostly former Soviet states in the Council of Europe, and they're mostly cases involving institutional type care, seeking into social care. So if I could ask you to turn to page 4852. His decision of Shukarov and Russia. Mine's upside down.
Well, it's only the first page that's upside down.
My first page is upside down.
So if you don't ask us to read the head note, we are none the worse.
Challenging the court with this.
You can rotate it.
I wasn't planning to take you to the first page. The broad circumstances of the case are set out a little further on. Yes, if you go to page 4873, you see that heading alleged violation of Article 5.1, various submissions are set out, and the circumstances of the applicant's case are described. He's contending his placement in the hospital had been a deprivation of liberty, placed in a locked facility. He attempted to flee, tied to the bed, given increasing dose of sedative medication, and not allowed to communicate with the outside world. Subjected.
So you're reading from
It's the
paragraph.
bottom of 4873 and the top of 4874.
Does he have mental capacity?
This is a detail that might be on the upside down page. Just 102.
Had a guardian.
Yeah. Yes, he had a guardian.
It says at 102 they relied on his status as a legally incapable person.
That's exactly right. So he didn't have capacity. The discussion of principle that's important from this decision is found at 4875, paragraph 108. So, and you'll see this echoed in later decisions. Court notes that indeed the applicant lacked de jure legal capacity to decide for himself. However, this does not necessarily mean the applicant was de facto unable to understand his situation. First, the applicant's own behaviour at the moment of his confinement proves the contrary. Thus, on several occasions, he requested discharge from hospital, contacted the administration and a lawyer, and once attempted to escape from the hospital. It follows from the court's above conclusions the finding of the domestic courts and the applicant's mental condition were questionable and quite remote in time. And based on that, even though he was incapable of expressing his opinion, de jure, they unable to accept the government's view that he agreed to his stay. Therefore, they conclude it's a deprivation of liberty. So, again, what's of interest here is how that analysis plays in the contrary situation, where someone is agreeing, positively affirming the circumstances of their confinement, not expressing dissatisfaction. Does that negate the deprivation of liberty?
So he had a de facto ability to object.
Yes.
Yeah. Did he?
Query, does one have a de facto ability to agree? So one has then DD Lithuania to similar effect.
Sorry, just on 109. It might say it's a slightly curious way round of putting it, because if he was legally incapable of expressing his opinion, he couldn't consent de jure to what was being done to him. So I mean, if one takes the stalk position that you look at the objective circumstances and then you look at the subjective attitude of the individual, would one say in this case that the person was objectively being confined, and if so, why?
He's objectively being confined in terms of when one looks at the causality factors and the circumstances in the concrete situation, the detail that's been set out at paragraph 101.
Right. So he's objectively confined.
Subjectively objecting.
He's legally incapable of consenting, but the court seems to look to see whether there's some other sense in which he could be said subjectively to be agreeing.
Exactly.
So this one, somewhat unlike Stork, seems less to focus directly on legal capacity and to look more at some slightly more nebulous or less bright line concept of valid consent. Is that right?
Yes. On the other side of legal capacity, so outside of legal capacity, looking at something which has legal effect or could have legal effect.
Right.
It's the answer's concealed in many of these cases because the individual is objecting. As I say, the real question comes in a situation similar to this where someone's agreeing or appears to be agreeing. What's the consequence of that?
It's a strangely worded paragraph 109.
But I think it may be, when they keep talking about him being legally incapable, if you refer back to the facts, the decision that he was incapable was not the same sort of exercise as we would hope was undertaken here.
Yeah.
The suspicion underlying this is that this was just to silence a dissident.
Well, and the court says at 102 that it was far removed in time, and it was a global capacity decision.
The suspicion is he had actually perfectly fine mental capacity. They just didn't like what he was doing with it, and so they decided in the process, which he had no access, that he lacked legal capacity. But that didn't actually prevent him from exercising what here would be thought to be normal mental decision-making.
Yeah. I did flag that these cases they have a certain character, and there's
yes,
more
but
like this.
so I'm not sure that this case is an example of someone who, having been assessed as having mental incapacity under a structure and test that is applicable in the UK, still has some relevant ability to express consent or lack of consent for the purpose of the second limb.
Perhaps one can take this from it. When one looks at 106, where they repeat the need for the subjective element, that the person has not validly consented to the confinement, they don't treat the answer to that question as being determined by whether, as a matter of domestic law, the person lacked capacity, which this person clearly did.
Yes.
Yeah. I mean, I think that's borne out by the way that they put it in 109, although it's a slightly odd way of putting it. It does seem that in 109 they're focusing on this slightly grey area beyond legal capacity, but still in some context, someone's sufficiently understands their position that even though they don't have legal capacity, they can give valid consent, seems to be the formulation that's used. But then that raises the question, well, what are the criteria for whether someone can give valid consent in that lesser sense or not?
Yes. Well, that's where our code goes. I suppose that's an attempt to capture that.
Well, using consent under our domestic law, you have to ask ability to consent to what? First of all, that's the very first question. And so we break it down into the ability to consent to various aspects of living, including the decision to be confined or to reside in a particular place. And you'd have to understand the outworkings of that before you have the ability to consent to it. But there's no Strasbourg authority that breaks it down in that way, is there? So that it looks specifically at whether or not the person can actually understand what deprivation of liberty means and validly consents to it.
I'll come to the case of Mikhailov's in a moment, which gets close to that. I don't think it does exactly that, but it
seems to be global. They look at it on a global basis rather than on an individual question basis.
Of course, when we're assessing capacity under the legislation, we assess capacity in respect of particular decisions in care and treatment, so it's focused on that, not an amorphous sense of capacity. What's happening in these cases is often there's a legal incapacity tailored or tethered to particular decisions, but we're then asking a wider question. Can that person agree to their location of living by whatever means are available to them, whatever expressions they can transmit? I'll give give you a reference to one of the cases. I'll pass over it just in the interest of moving on. DD in Lithuania is to similar effect. You'll find that at 4754. I'm not going to ask the court to read it. There's another Polish case called Kedzior, which is at 4840, paragraph 58 to similar effect. Again, I'm not going to ask the court to go to that now in the interest of time. I will ask the court to look to a decision of Stanev in Bulgaria, which is a 2012 decision. It's actually referenced in Cheshire West, and this is a social care case. So the individual's under guardianship, and he has been transferred to a social care home for his ongoing placement. The circumstances of the placement are set out.
You haven't given us a page number yet.
4884. I'm sorry, 4884. It's the head note. The circumstances of the placement were not Article 3 compliant. You'll see that at H2 of the head note, page 484. It is so poor as to amount to inhuman and degrading treatment. You'll see the detail of that.
Paragraph?
That's H2, my lord, on page 4884. The detail of it is found at page 4889, paragraphs 18 and following. It's again a consideration of the Stork test in this case. You'll see that
So Stanev is Grand Chamber, is that right? There's
yes.
a lot of judges, yeah.
So the assessment is at 4908, paragraph 115.
Sorry, 115.
Yes, 115. This is Grand Chamber affirmation of Stork, and you'll see that at 116 and 117. 117 in particular, affirming the subjective test. And you'll note at 117 a reference to that as the additional subjective element. The individual has not consented to the confinement in question. Footnote 58 takes you back to paragraph 74 of Stork, which we've already looked at. So that's a clear affirmation that there's something additional being done by the subjective test, in addition to the Gazzardi general objective approach. And there's some examples at 118 of what's been found to be a deprivation of liberty. I won't read those out, but those link to some of the cases we've already looked at. The Shuktakorov case, Stork and HL are the decisions that are sourcing those three positions. The court then deals with the objective element of the test, and again, the nature of the environment already, I think I've alluded to that.
Sorry, where are you now?
I'm sorry, this is at 124 onwards, my lord. This is 4910, going on to 4911. And then the subjective test is dealt with at 130. And I'll not read 130 out, but if you go to the page 4912, you'll see about 7 lines down. However, the court's already held that the fact that a person lacks legal capacity does not necessarily mean he's unable to comprehend a situation that should occur of. In the present case, domestic law attached a certain weight to the applicant's wishes and appears he was well aware of a situation. He explicitly expressed his desire to leave with a psychiatrist and through his application to the authorities to have his legal capacity restored and to be released from guardianship. These set the case apart from HM Switzerland, which we've already looked at. and the bottom of that paragraph, the court's not convinced the applicant consented to the placement or accepted tacitly at a later stage and throughout his stay. So one sees there the concept of tacit acceptance, and that develops as the case law goes on. But having regard to the particular circumstances, the nature of the placement, the lack of consent, the court concludes the situation amounts to a deprivation of liberty in the meaning of Article 5.1.
Something that puzzles me a little bit about this jurisprudence is whether the subjective factor is being treated essentially as a defence. So you go through the objective indications, conclude, yes, all things considered, this looks like a deprivation, but has the person consented to it, in which case you then step back and say, not a deprivation? Or is it being built into that initial assessment, whether it is a deprivation at all? This almost has the flavour of that it's being built into the initial consideration, whether it's a deprivation at all.
Then what to make of the additional, the court flagging that's in the subjective element is an additional component?
Well, that's why I'm raising the puzzlement. So you could look at it as it's a defence. It's additional because people should, courts, authorities should consider, even if it appears objectively to be a deprivation, nonetheless there's consent, in which case we'll treat that as an additional indicator whether it is a deprivation or not. But in effect it's operating as a defence. Or is this assessment of absence of consent or valid agreement, whatever terminology one wants to use, being built into the initial assessment, whether it's a deprivation at all? Can you help with that? Where are we going to go with these authorities on that?
I think you find a very clear steer to this in DD and Lithuania.
Yes.
On page 4846. If one looks first at paragraph 55, the court observes the notion of deprivation of liberty does not only comprise the objective element. A person can only be considered to have been deprived of his liberty if, as an additional subjective element, he hasn't validly consented. Then you see at 58 how they deal with subjective element, reiterates that the fact that a person lacks de jure legal capacity doesn't necessarily mean he's de facto unable to understand his situation, while accepting that in certain circumstances, due to the severity of his or her incapacity, an individual may be wholly incapable of expressing consent or objection. The court finds that this was not the applicant's case. The applicant subjectively perceived his compulsory admission to the hospital home as a deprivation of liberty, and therefore the definition is met. It's
built into the first stage, the objective indicators, rather than being treated as a defence element within the overall definition. Is that right? Is that
appears to be
you
correct?
adopt?
Yes.
But then how does that fit with your case in relation to the code of practice? Because I thought that you were focusing on, well, maybe you're focusing on the subjective element as part of the positive assessment, whether under the objective limb of the Stork approach. Is that right?
What's clear, in other words, it has to be given some weight, the subjective element of it. It fits potentially into the objective consideration. So what we say must happen is it must be something that's had regard to in the analysis. It can't be excluded, can't be avoided.
Well, it may be right or it may be wrong, but according to this passage we've just looked at in DD and Lithuania, it's an essential element of deprivation of liberty.
Do you know, do we see DD being referred to in later cases?
DD is referred to, yes, you will see that. This suite of cases, Shutukurov, DD, Kedzior, are all referred to again and again.
Well, indeed, as paragraph 55 indicated, it comes straight, is lifted straight from Stork, paragraph 74.
Yes.
Yes, although in Stork, as we looked at it, that seemed to be focusing on legal capacity, whereas this is. Oh no, it's true. No, they looked at legal capacity and valid agreements additionally, didn't they?
Strasbourg authorities seem to be clear that you can't consent to deprivation of liberty. The issue is about confinement. So can you consent to the confinement?
Yeah.
If you consent to the confinement, then there's no deprivation of liberty that follows. That's the way in which the court seems to have dealt with it.
Yes, so the absence of de facto consent has to be demonstrated before there will be a deprivation of liberty.
Yeah. Well, that seems a sensible reading of paragraph 74 of Stork.
There you're looking at deprivation of liberty as all three elements rather than confinement, which is the first element.
Sorry, I'm really not following.
It's clear from Stork that for there to be a deprivation of liberty, contrary to Article 5, all three of the limbs must be present. I think what we're wondering is whether the absence of consent is only relevant to the second limb, or whether it's also relevant to the question of whether the person is confined.
Let me come back on that point, lady. I was going to take it to an authority that brings the issues into sharper relief.
Well, the way it's put in Stork, the subjective element is the absence of consent to the confinement in question. So there has to be objectively confinement, and then subjectively an absence of consent to the confinement.
That's right.
Yes, so three elements in deprivation, relevant deprivation of liberty: objective confinement, absence of consent, and imputation to the state.
Yes. Can I then ask you to turn to Mihailov's in Latvia? That's at 4970, Chamber decision, 2013. So this is a transition from institutional care into social care. It's a case involving guardianship and also involving legal incapacity. You can see that page 4973. So paragraphs 12. His wife initiated proceedings to have him divested of legal capacity. The court ruled he wasn't legally capable, and thereafter his wife asked to be placed in a specialised state social care institution. That's at paragraph 16, and forms were filled into that effect. Page 4975, the applicant was admitted to the EEL Centre. Individuals could move around freely within the centre, but needed to inform management if they wished to leave. Individuals divested of legal capacity and wished to leave had to have that request agreed by guardians. And in regard to the applicant's state of health, he was included in a risk group. Patient with epilepsy was permitted to leave only if accompanied by a staff member or another patient. So control conditions applied, HL, etc. Paragraph 26 is important. At the request of his wife in October 2010, a referral was issued for the applicant to receive social care in another branch of the State Social Care Centre in Ikava, 45 kilometres from Riga. And on an unknown date, the applicant refused to move to the Ikava branch since he felt well in the EEL Centre and didn't want to move to another institution. So he wasn't agreeing, so he doesn't have capacity and he's not agreeing to the move. This case is very interesting because it has both sides of the coin. It has the applicant objecting without capacity to one move and accepting another. So you'll see that how it develops in this case. It's also a decision which is informed by the CRPD, so the United Nations Convention on the Rights of Persons with Disability. You'll see that at page 4981 and paragraph 62, which is quoting Article 12 of the CRPD. And the court looks to the top of page 4982. You'll see subsection 4982, my lord. This is the numbered paragraphs here are within Article 12, CRPD, and I'm highlighting subparagraph 4, which is referring to the state parties ensuring all measures that relate to the exercise of legal capacity provide for appropriate and effective safeguards to prevent abuse in accordance with international human rights law. Such safeguards shall ensure that measures relating to the exercise of legal capacity respect the rights, will and preferences of the person, are free of conflict of interest, undue influence, proportional, tailored, and so forth. So you see in the text of the UNCRPD 12, subsection 4, a reference to the will and preferences of the person. So CRPD came into effect in 2008 and ratified by the Latvian government in 2010. It's a factor in this case, and you will see the language that's used in 12.4 appears later in the analysis section of the judgment. So there are two placements that I've said, and these are dealt with. If you turn into the assessment section of the judgment, that's beginning at 4998. You'll see paragraph 128. Deals with the objective-subjective test, and again, the point we've been exchanging on is at the bottom of that first paragraph 128. A person can only be considered to have been deprived of his liberty if, as an additional subjective element, he's not invalidly consented to the confinement in question. Back to section 74, paragraph 74 of Stork. You then have the two scenarios considered. The Eel Centre in Eel Parish is the first scenario, and this is a case where the applicant objected. You'll see how that's dealt with at paragraph 134. The court, this is page 5000, the court next turns to the subjective element, which is also disputed between the parties. The court reiterates the fact the applicant lacked de jure legal capacity to decide matters for himself does not necessarily mean he was de facto unable to understand his situation. Shuk de Korov referenced again. While accepting their situation with the wishes of a person with impaired mental faculties may be validly replaced by those of another person, and that it's sometimes difficult to ascertain the true wish or preference of a person concerned, the court finds this was not the applicant's case. So I'm highlighting the wishes and preference concept there, which links back to Article 12 for CRPD. The documents presented to the court indicate the applicant subjectively perceived his compulsory admission as a deprivation of liberty, contrary to what the government suggested, never regarded his admission as consensual and objected to it during his stay there. So that's the first case. Second case then is from 138 onwards, the Eel Centre in Lille Bears.
Do they break this down into objective, subjective?
Yes, they do, my lord. So, looking at 138, the court has doubts about whether it can be considered being deprived of his liberty in Eel Centre, Lille Bears. The court refers to the fact the applicant acknowledged the Eel Centre had been an open institution. Further notes he himself had refused to move to another care centre, namely the Ikiva branch, by pointing out he was satisfied with his stay in the Eel Centre. Didn't contest that before this court. They note at the top of the next page that he could have complained under the municipal law about his placement. No suggestion he had approached any authority to allege a breach of his rights. The court cannot but note he did exercise that right while residing in the Eel Centre in the other location. These factors, in contrast to examined under the previous subheading, are sufficient for the court to consider the applicant the government have shown the applicant had tacitly agreed to stay in the Eel Centre in Lille Berge. Therefore, the court accepts the government's objection the applicant was not deprived of his liberty within the meaning of Article 5.1 of the Convention. So here we have the two sides brought together in one case: incapacitous patient or person in the social care arena, accepting one location through the expression of his wishes and preference and not the other. And one has two different outcomes in terms of deprivation of liberty.
What was this case? I'm not sure what its timing is. Was it before the court in Cheshire West?
Yes, it was. It was. And we look at how that's analysed, and clearly the court in Cheshire West were wrestling with the import of this decision, and there are some parts of the analysis which seek to distinguish it, and others which draw something significant from it. So we will look in due course at the Cheshire West analysis, but this decision is important in that regard because it's an indicator of the subjective element of the Stoic test being applied as a defining concept. It shows the Strasbourg Court considering expressions of wishes and feelings of an incapacitated patient as a key factor in terms of deprivation of liberty in a social care setting. So Emile Haylovs, we say, is a very significant Strasbourg authority on the point. It's pre-Cheshire West. What has become of this line of reasoning post-Cheshire West? Well, the same analysis continues to be applied. We have highlighted the case of Chervenka and Czech Republic. That's at page 5238. It's another incapacitous case. You'll see that in the first paragraph on 5238. Admitted to psychiatric hospital several times, deprived of his legal capacity by the district court. Issues in respect of alcoholic dementia, prevented him from performing any legal acts of his own. There's a guardianship arrangement in place and disputes about the placement. I'll take this fairly shortly. If you go to page 5251, paragraph 102, see the court notes it's already had opportunity to examine the placement of mentally incapacitated individuals in social care homes, found it amounted to deprivation of liberty, and that's Stanev, Shutikorev, DD, and Lithuania. Sikora, a case we haven't looked at. And then discussion of the present case at 103. So, declared to be fully incapacitated at the relevant time. Government admitted he could not leave the care home on his own during the day without being accompanied.
I'm so sorry, which paragraph?
Sorry, that's 103, my lord. This is on page 5251.
Yes, thank you. Yes.
So, records his lack of capacity, records his inability to leave on his own. He's compulsorily placed on the basis of an agreement signed by his guardian. While he did not show clear disagreement on the day of his admission to the social care home shortly beforehand, from his subsequent conduct it was obvious he had not consented to his placement there. Again, the court is searching for an expression of agreement or disagreement from the incapacitous patient in this context. The answer in this case is there is an obvious lack of consent, and in light of the foregoing, the court concludes the applicant was deprived of his liberty within the meaning of Article 5.1. So we see again here, it's not exactly the same as Haylovs, obviously. It's not a case of agreement, but it's the same concepts being traced through in later cases post-Cheshire West in 2016. Two other points about the Strasbourg jurisprudence, moving off the subjective element for now, so that's probably as much as I want to show the court on that line of authority. I just wanted to touch on the issue of the importance of coercion in this context. And I could take you to the case of Ferhat in Turkey. That's at 5013. And just a statement of principle at paragraph 35 of this chamber judgment at 5020.
Sorry.
5020, paragraph 35.
Thank you.
Slightly different context, but the court here is concluding. According to the court's established case law, coercion is a crucial element in the examination of whether or not someone's been deprived of his or her liberty in the meaning of Article 5.1 of the Convention. So we look again to the place of coercion in the overall analysis, and we'll look to that whenever we come back to Cheshire West.
Is coercion anything more than the absence of consent?
You see how it's expressed in this case? It's a case of manhandling,
manhandled and physically
dragging
dragged into the room,
yes.
so that's certainly coercion.
Yes.
But are you making some point that coercion is something that's required in addition to just lack of consent?
That's what the Strasbourg court seems to be saying, and you'll see whenever we come to Cheshire West, there's an argument about the importance of coercion in that context. I'll take you to that in due course. I'm just flagging this now as another feature of the Strasbourg jurisprudence, and I'll come back to that. To similar effect, relatedly, another factor to consider can be taken from the Grand Chamber decision of Ruman in Belgium. That's at 5482. This is a case about, or was about, Article 5 and Article 3 considerations. There's a statement of principle in this Grand Chamber decision, which is to be found at page 5524. Now, again, I acknowledge this is under the court's assessment of Article 3 considerations, but Article 5 was also in play in this case. And you'll see the statement of principle at page 5524. Paragraph 142, measures depriving persons of their liberty, it said, inevitably involve an element of suffering and humiliation. So, again, there are uncertainties in the jurisprudence, as the court in Cheshire West ultimately acknowledges, but you can see in the basket of issues that are in play.
I'm sorry, the sentence you're relying on.
142, we wrote one sentence in one paragraph.
Thank you.
Elements of suffering, humiliation. Ferhat in Turkey. There's another decision of Foka in Turkey, I think.
So is the significance of paragraph 142 here that you're saying someone needs to be conscious that they're being confined in some way in order to have feelings of suffering and humiliation?
Otherwise, it's not. That appears to be
concept.
An essential consideration.
But that was in the context of Article 3.
It is, yes. I don't want to overplay the point,
Yeah.
and I don't overplay it. I recognise all of that. It's in Article 3 debate. The court's expressing that principle in that context, but again, one can't ignore it in the analysis. That's probably taken me up to the point where I was going to turn to Cheshire West. I think it's got close to 1 o'clock.
Yes, if that's a convenient moment, Ms. McGleenan, we'll adjourn and resume at 2 o'clock.